appeal in the matter of AM's Corporation AG and Supponor Ltd.
Yes, Mr. Nicholson.
My lords, may it please the court, I appear with Dr. Iverson, Supponor, my learned friends, Mr. Alexander, King's Counsel, and Mr. Cronin, appear for the patentee, AIM Sport Development AG. Just for your lordship's reference, you may have seen the patentee has changed its name since first instance. It was originally AIM Sport Vision AG. It's now AIM Sport Development AG. And by the order of this court, which is in the supplemental bundle at paragraph 16, development has been substituted as a party and now stands instead of vision for the purposes of this appeal.
But it's the same. It's actually the same party, but different name. Is it?
My lord, it's slightly complicated because it's a merger under Swiss law, as I understand it.
Okay.
But as between the parties, all your lordships, I think, need to take into account is that the judgment should hopefully say development rather than vision.
Okay, thank you very much.
My lord, second point of housekeeping, an issue of confidentiality. There's a final enduring 3122 order in respect of the confidential parts of the product and process description. It's in the supplemental bundle at tab 7. The version of the PPD that's in the bundle at supplemental 3 is the confidential version. I've discussed the matter with my learned friend, and we don't believe there will be any need to refer to any of the confidential information at this hearing. Certainly it's not referred to in the judgment or the skeletons. But I just wanted to make your lordships aware that we need to be careful if we dip into the product and process description itself. I do have marked up redacted copies available in court, so should the need arise, those can be produced. But I just wanted to let you know.
All right, well, we'll leave it to you then, between you, to alert us if that point comes up. Does the existing order cover proceedings in this court?
My lord, I believe it does. It's an enduring one in the final order, but insofar as anyone says otherwise, and I don't understand my learned friends to say otherwise, then I would obviously ask for the usual order. My learned friend shaking his head, I think he's content that the existing order is effective.
Yes, all right, well, in that case, we don't need to make any order.
I'm
Since
grateful, my lord.
Since you've just referred to the document, then potentially that is in play, but if the existing order covers it, then that seems fine.
I'm grateful. My lords, this is my client's appeal against Mr. Justice Mead's decision that a single method claim of the patent is valid and infringed by certain aspects of one of my client's products, which has been known in these proceedings as the SVB system. There's no respondent's notice. My learned friend's content to stand behind the judge's decisions for the reasons he has given. And we make that point at the outset because we found it quite difficult to see my learned friends directly engaging with the specific points which we have made. And there is perhaps some desire on their part to traverse material which doesn't form part of the judge's reasoning. Now, in terms of timing, the estimate for the case is 2 days. I've discussed this with my learned friend, and subject to your lordships, I'm aiming to finish a little bit before the end of the day. That will enable my learned friends to make a start this afternoon, continue after the short adjournment tomorrow, giving me a short reply in the second half of tomorrow afternoon.
Yes, well, we were rather thinking that it seemed unlikely that the full 2 days would be needed. If they really are, then they're available.
It is possible. It is possible.
It's basically an issue of construction of the patent with some further points following on from whatever the true construction is.
Indeed.
We see it at the moment.
Indeed, my lord. I'm going to start with an overview of the technology with which the patent, prior art, and my client's system are concerned. Then I'll turn to the teaching of the patent, and in particular, the construction of the only claim in issue. I'll briefly introduce the prior art document, which is my client's own patent application, Nevity, and finally introduce my client's SVB system. And then against that background, I intend to work through each of the 6 specific grounds of appeal, showing where we say the judge went wrong. Your lordships will have seen from our skeleton that we've grouped our grounds together, and as my Lord Justice Males has just commented, we've got 4 construction points. That's grounds 1, 2, 3 and 6, and then freestanding obviousness, proper legal approach to obviousness as our ground 4, group B, and then finally we have our group C, which is my ground 5. This somewhat incorrectly acquired the moniker of the prompt you point below. The essence of the point is the legal consequences of AIM having admitted very shortly before trial that its product claim was invalid in the light of the prior art. The trial judge permitted AIM to maintain its technically equivalent method claim, even though AIM accepts that there's no difference in technical contribution between the two claims. And we say he was wrong to do so. So unless I can assist your Lordship further at this stage, I'll turn to the technical background.
Yes, thank you.
What are we trying to do? The field of technology is about digitally replacing specific parts of images with other images. The paradigm example where this technology may be used is at a televised sport event, such as a football match, where there are advertising boards around the pitch. This is a paradigm example, although it's the example used in the description of the patent, and the patent's single remaining claim is no way limited to that application. And we point out that the football match is only an exemplary paradigm case, because when it comes to construction, my learned friend's case has always depended on construing the claim as if it were implicitly limited to this paradigm embodiment. And in so doing, it makes the well-known error of glossing the claims with features from the preferred embodiment. With that caution in mind, we can stick with the paradigm example of a football match for the time being. And your Lordships are hopefully aware of the billboards that go all around the edge of a pitch at around waist level. And perhaps we could actually have a look at one. It's in the supplemental bundle at tab 20, the first page of that bundle, which is 237. This is actually an ice hockey game, but the billboards we're talking about are the hoardings or billboards that appear predominantly white, starting in the lower left saying Wells Fargo, then Models, Kia Motors, Sorrento, NHL.com around the edge of the board. These advertising billboards have two jobs. They advertise to people who are physically present in the sports stadium, and they advertise to people who are watching by television. Unlike conventional television adverts, which are usually played during a break in the game, these pitch-side adverts appear on the viewer's screen throughout the match, generally without interrupting the game the viewer is trying to watch. And an issue with this then arises. What if the people who are watching on television aren't the target audience for the adverts being shown on the advertising billboards? Perhaps in the United Kingdom, we aren't interested in Wells Fargo or Morel's Sporting Goods, or maybe even NHL.com. If the sport match is taking place in one jurisdiction but being televised the world over, the broadcaster is not going to be able to charge an advertising fee for showing adverts on its TV channel which nobody is watching in the country where it is being shown. Perhaps a more acute example arises with advertisements for particular products, such as alcohol. Advertising alcohol is prohibited, or at least very restricted, in certain jurisdictions. And that means that either alcohol advertisements can't appear on the billboards in the ground at all.
I think we all understand this much, that people want to be able to show different adverts on the broadcast than they show in the ground.
I'm grateful.
And the reasons for that. So you don't need, I think, to elaborate that.
The basic and known solution to this problem is to digitally manipulate the broadcast TV images to replace the adverts being shown on the billboard with other adverts which are relevant and appropriate to viewers in each jurisdiction. And the idea of selectively overlaying images in TV broadcasts wasn't a new idea at the priority date. The concept was part of the common general knowledge, and the subject matter of my client's own prior art, Nevity. Chronologically, the patent's priority date slips in between what Supponor disclosed before the patent was applied for, that's Nevity, what Supponor was doing after the patent, that's the SVB system. And we say for this reason, precisely what the AIM patent discloses and the specific differences between the patent, Nevity, and the SVB system are important and are at the heart of the dispute. Put another way, the alleged invention in AIM's patent is not about the general idea of overlaying digital images on billboards. It's necessarily about the specific technique which the patent teaches. Now, when one sets about this task, there are two main problems. The main challenge is dealing with occluding objects. However one goes about trying to get the billboard replacement taking place, one issue that has to be addressed is the objects that come in front of the board. Looking at the pitch-side billboard advertising in this picture, if your lordship still have it out, for example, it is inevitable that objects are going to find themselves between the billboard and the TV camera. In the figure, your lordships can immediately see that there are lots of moving objects between the billboards and camera. We have players from both teams, hockey sticks, the referee in this frame alone. And whilst this is obviously a single frame, the objects are clearly moving quickly and are capable of finding themselves temporarily located between the billboard and the camera. There are also static objects that can become interposed, such as the goalposts. Even though these are static, their position relative to the camera and the billboard may change as the camera angle changes, so they become interposed and obscure part of the board. Now, in order to seamlessly digitally overlay adverts within the TV image, such as the one we're looking at, you must take account of these objects. It would be somewhat jarring for the viewers if parts of the scene that were in front of the billboard were suddenly obscured by some part of a digitally inserted advert. What one has to do is to find a way of either not overlaying the occluding objects, or to look at the problem differently, only overlaying the bits of the billboard which are within the unobstructed view of the TV camera. And of course, the engineering team doesn't know in advance where the players will be or what the camera angle will be, so the solution to handling occluding objects needs to be one that can cope with objects appearing in substantially unpredictable ways. Furthermore, the engineering team can't dictate what the players might wear. As we can see in this image, some kits are predominantly red, some are predominantly white. Players on both teams are wearing black shorts. The referee is wearing a black and white striped top and black trousers. Each team chooses their own colours, and indeed the shirts additionally have names and numbers added to them. Now, just before we leave this picture, another aspect that I just want to point out is that the billboards appear in a perspective view in the camera image. In a particular frame, this particular frame, the Wells Fargo part of the billboard is at something of a side view at an angle, changing the shape of the billboard to something of a rhombus. Whereas at the other end of the hoarding is becoming almost perpendicular to the camera or approaching it. The NHL.com logo is getting closer to being head-on, such that it's more rectangular in shape. And the point that I make, and I'm sure my lords will appreciate, is that as the camera pans, tilts and zooms, not only the relative position of the billboards change, so too will their apparent size and shape. This also has to be addressed for a proper overlaying process to take place. And the issue is, however, much simpler and had long been solved before the priority date of the patent, because the billboards don't actually move in the real world, and the cameras provide telemetry information as to their pan, tilt and zoom, which allows the position of the billboards in the camera image to be calculated from the known position in the stadium, and it's a matter of simple 3D geometry. The overlay image can then be stretched and warped to fit the current perspective, size and shape of the billboard. Now, returning to the overlay process.
I did have one question about this page before we leave it. Are the Toronto maple leafs not very good?
I'm sorry, my lord.
Are the Toronto maple leafs not very good?
Toronto.
Oh, never mind.
I'm sorry, my lord. It's completely passing me by.
Never mind.
Conceptually, there are two ways of going about this overlaying task. One is to go about finding only those parts of the billboard that are visible in the camera image. The other is to make use of the fact that the positioning of the billboard has to be calculated anyway, and then set about finding any objects that occlude the billboard in the camera image. To better explain, in the first way, you process a camera image to locate the parts of the billboard that are visible, and you overlay just those parts. That's conceptually a two-stage process, although of course there's more going on in the background. But the first stage is look in the camera image for some sort of special signature or defining feature which is distinctive of the billboard and none other, to directly locate only the visible parts of the billboard. And then, of course, second stage, you can overlay those. And that works because any occluding object blocks the camera's view of the special signature from the billboard. And this is very similar to how green screen works in a TV studio. We have an example of that in the core bundle at tab 8, page 106 in blue. The presenter stands in front of a green background, and the system looks for the pure green parts of the image, the signature, and overlays them, for example, with a digitally created weather map. The system doesn't need to know and doesn't care why part of the image isn't green. It could be because the view of the green background is blocked by the TV presenter, or by a coffee cup, or because the green background only takes up part of the frame. All it needs to know is to overlay the pure green parts and not overlay anything which isn't pure green. In this system, the special property or signature of the background is the colour green. Exactly the same thing could be done with blue, for example, or red. If the presenter or the guest accidentally wears a green tie, one can end up with part of the background accidentally appearing on the presenter's tie. And in fact, this is shown in this example because, as you can see on the left-hand side, the presenter is holding a piece of paper with some green on it, and in the right-hand image, that has been replaced digitally with part of the weather map, even though it's an object in front of the screen. This is what I'm going to call a billboard signature system. The way this is done in sports systems is slightly different, I should make clear, because we want to display adverts on the real billboards and not just a green screen. So the colour that we use is a non-visible infrared band for the signature. But the principle of giving the billboard a distinctive signature is the same. The second way of approaching the problem is a more complicated three-stage process. First, you work out where the billboard should be in the image by calculating from the camera telemetry information and a 3D model. And then second, you digitally process the camera image to identify whether there are any occluding objects appearing in the part of the image where the billboard should be. Third, you overlay any part of the image where the billboard should be and where no occluding object has been detected. In other words, you notionally subtract the occluding object from the area which you expect the billboard to appear. So you have two ways of conceptually approaching the replacement problem. Although the objective, finding the bits of the TV image that need to be overlaid, is the same, and the result is largely the same, if not identical, the two approaches are conceptually and technically different. That is what Ames expert Dr. Thomas said in his evidence. And we can look at that in Supplemental Bundle, tab 10. Page 157 in the blue. And paragraph 102. He says, it is important to note that Nevity approaches the problem by detecting visible areas of the billboard, whereas the patent approaches it by detecting any including objects. The end result may to some extent be the same, but the underlying mechanism is technically and conceptually different. At this conceptual level, we entirely agreed with him at trial, and we still agree with him. In this paragraph, Dr. Thomas is comparing and contrasting the prior art Nevity with the patent. He's pointing out that Nevity is the first type of system, the billboard signature system, which uses that signature to find the billboard and overlay the bits that can be seen in the camera image. That's what Dr. Thomas said, and we agree with him. And in contrast, he's pointing out that the patent is about the second type of system, one that sets out to find occluding objects, which it then subtracts from where it expects the billboard to be and overlays the non-occluded parts. Again, that is also what Dr. Thomas said, and we also agree with him. The issue between the parties arises because the alleged infringement, the SVB system, is the first type of system, one which uses a billboard signature and does not search for occluding objects. This left AIM in the difficult situation of seeking to construe its claim to cover both types of system, but then avoid walking onto the prior art. And obviously I'll come back to that, but my lords will see the tension. I then move on.
I thought the SVP system is, at any rate sometimes, a combination of both methods. And that was the problem, as the judge found.
That's the mistake that's effectively made, because the SVB system never detects occluding objects. It has two cameras, one that operates in a light channel and one that operates in a dark channel. And this is where, cutting to the chase, we say the judge went wrong, because he confused lightness and darkness of camera channels with the fundamental concept of what the patent is teaching, which is the detection of occluding objects. A further challenge exists when one sets about solving the problem of billboard replacement. Going back in time, advertising billboards around a sporting event, such as a football or an ice hockey match, was simply printed posters, very much like the ones we see in that supplemental tab 20 that we were looking at. They may have been backlit, but the important thing is that they were static images. Now, long before the priority date of the patent and forming part of the common general knowledge, these static billboards started to be upgraded to dynamic digital moving image displays. If my lords have watched any televised sport in recent years, you may well have seen animated and scrolling advertisements being continuously displayed on the billboards throughout the game. These animated displays make the adverts more eye-catching, and they also allow the same advertising space to be sold to multiple advertisers, each of which gets their advert shown for a proportion of the time. But what matters for present purposes, and was common ground at trial, is two things. Firstly, in order to display these moving images, these displays emit visible light to make up the image pixels of the displayed object. Second, the displayed images change over time, so they're not constant across a series of contiguous camera frames. Now, we have a number of photographs in the evidence of the sort of technology which was in use for large format display screens, suitable for use as billboards. And perhaps we can have a look at a couple of those in Supplemental Bundle, tab 13, page 191 in the blue. Here, Professor Steve is showing a close-up of the construction of a large format display. In the predominantly green figure, each pixel is formed of 3 separate light-emitting diodes, one red, one green, and one blue. It is a much larger scale than, for example, a modern computer monitor or a mobile phone screen, both of which nowadays have pixel groups so tiny that individual pixels cannot be seen with the naked eye. In contrast, these large format displays have fairly large pixel sizes, giving out a lot of light because, unlike a computer monitor, they're designed to be viewed from tens to hundreds of meters away. And whilst we're here in Professor Steve's report, at paragraph 36, he also says another simple approach might involve mesh LED screens, which had gaps between the LEDs or rows of LEDs. These were commercially available, as is apparent from a 2012 catalogue, which he exhibits, but we don't have in the bundle. Now, at this point, I can pick up the patent, which is the Supplemental Bundle, tab 1. It's titled Digital Overlay digitally overlaying an image with another image, and it has a priority date of the 13th of May 2015. Given that there's only one remaining claim, that being original claim 12, rather than wading through the whole of the patent, which my lords will no doubt already have read, it's convenient to discuss the patent's presented solution using the framework of the claim. Of course, the claims must be viewed purposively, and we can drop back to relevant paragraphs of the specification, and I'll do so, to better understand the patentee's purpose where necessary. Because it's been broken down helpfully into integers, the best place to look at the claim is in the judgment at core 8. And it's page 114 in blue. But if it, as your lordships will see, the principal claim splits over the page. And if it would assist your lordship, I do actually have copies of the claim on a single sheet. I don't know whether your lordships would like to have that.
Well, as you've gone to the trouble of doing it for us, let's have it.
I'm grateful, my lord. Clipped to the back of it, excuse me. Yeah. Clipped to the back of it is also the copy of the 2 amended claims. Thank you.
Thank you very much.
Now, looking at Claim 12 as granted on the first page of the note, I want to go through this carefully because it's at the heart of the dispute, and it is a rather long and involved claim. First, let's look at the structure of the claim. It's a method claim to digitally overlaying an image with another image. There are 6 distinct steps that we've numbered 12.1 through to 12.6. Creating, identifying, capturing, positioning, detecting, and overlaying. Starting at the top, integer 12.1, creating a model of a real-world space. As we've discussed as being an aspect of these digital overlay systems, this integer requires a model which is used later in the claim to work out where the billboard is expected to be in the various camera images, based on the position of the camera system at the present time. It has 2 sub-integers, 12.1.1 and and 12.1.1.1, which add additional requirements about the existence of an overlay surface in the model. 12.1.1 requires that the model includes an overlay surface to be overlaid with an overlay image. This makes clear that the overlay surface is the thing that is going or potentially going to be overlaid in this claim about a digital overlaying of an image. At 12.1.1.1, it requires that the overlay surface in the model represents a display device in the real world. In other words, the model surface corresponds to something that actually exists in the real world. It isn't just some theoretical position for inserting imagery. Just pausing there, in the paradigm example of a football match, the real world space is the football stadium, and the display device might be a pitch-sized billboard inside the stadium, such as those that run round the outside perimeter of the pitch. The claim requires you to create a computer model of that sports stadium. It doesn't need to be a model of every last detail, but what it needs to include is a representation of a surface which represents the real size and placement of the display surface of the pitch-side billboard. Now, of course, the claim isn't limited to the paradigm case. Nothing in the claim so far, and as we'll see subsequently, imposes any limit on the real-world space being represented. It could be inside, it could be outside, it could be the size of a stadium, or it could be a small TV studio. It could even be this courtroom. The display device could be huge, it could be small, it could be square, it could be round. The claim doesn't seek to specify. It could be an advertising board, or it could be a scoreboard, or it could be something else.
You think HMCTS is missing a trick on not displaying adverts on the live streaming of this hearing?
The point I was to make, my lord, it could be the screen in the corner of this room. Now, it may be that not advertising, but it may be that I want to put up confidential documents and show them to you on screen. This technology could be used to ensure that in the live streaming, that information isn't broadcast. It's replaced with something else. So moving on, the next integer, 12.1.1.2, adds further requirements for the display device, specifically wherein the display device is configured to display a moving image on the display device in the real world by emitting radiation in one or more predetermined frequency ranges. Now, notably, this is about the display device in the real world, not its representation in the model. But the claim's only two requirements are that, firstly, it is configured to display a moving image, and secondly, that it does so by emitting radiation in one or more predetermined frequency ranges. Otherwise, the claim imposes no limitation at all on the properties of the display device. So, for example, it could be an LED display, but it could also be an LCD or a TFT or a conventional TV monitor like the one that's on the wall.
It may not matter, Mr. Nicholson, but I didn't think LCDs emitted radiation.
My lord, the way the patent describes it, and I think it's 13 or 26, the way the patentee describes it is reflecting radiation on those,
Okay.
but sorry.
Okay.
Emitting or reflecting. But there's also, my lord, those LCD displays that have a significant backlight panel to them, and then the LCD works as little rotating flaps of a very tiny size, so that the light is still emitted from the screen. So picking up by the emitting radiation in one or more predetermined frequency ranges, the type of display device which the claim includes are ones that can display a moving image by emitting carefully controlled combinations of red light, green light, and blue light in thousands of pixel or regions arranged in a grid, just like the clusters of 3 red, green and blue LEDs in the ones we looked at in Professor Steed's report. Now, my lords may appreciate that full colour displays don't actually emit light over the full visible spectrum. They generally only emit a narrow band of red, a narrow band of green and a narrow band of blue. The impression that we all get of full, or most of us get, of full colour is created in the human mind because our eyes are only sensitive to red, green and blue colours. And we perceive colours interspersed in the rainbow between those three principal colours by interpolating between the levels that we see of the three colours. And the patent explains that specifically in paragraph 34, which is in the supplemental bundle at tab 1. Page 7, and I can pick up at line 39. Each LED of a pixel can have a unique colour. For example, in most known configurations, it will be red, green and blue. These are called the base colours. By mixing these base colours, these boards can create the visual perception that any other colour can be generated. So if the display device were an RGB, a red, green, blue colour display, it will emit radiation in 3 distinct predetermined frequency ranges in order to display a moving image on the display device in the real world. Those frequency ranges are predetermined by the manufacturer of the display, who selects particular characteristics of their red, green and blue LEDs. But integer 12.1.1.2 is not, however, limited to full colour display devices. Most obviously, it expressly includes devices which emit radiation in only one predetermined frequency range. So, for example, it would include a display board with an array of large red LEDs, which produces a moving monochrome red advertising image. You could imagine a board with an array of quite sizable red LEDs installed on a solid white backboard, which makes use of the white backboard as contrast to dynamically scroll the well-known red and white Coca-Cola logo from side to side by turning the LEDs on and off in the appropriate pattern. And if we think back to the ice hockey situation, you can quite imagine Coca-Cola scrolling all the way around the outer periphery of the ice hockey rink during the course of the game. The important property of the display device of the Claim is the light which is emitted to display moving images for spectators in the stadium is emitted in predetermined emission frequency band or bands. And to illustrate this point further, we can look back at the patent's teaching in figure 5A, which is on page 20 of supplemental bundle tab 1. And what we have at 5A is a graph of emission intensity from the display shown on the y-axis and wavelength on the x-axis. Paragraph 34 at lines 49 to 52 explains the LED board will have a frequency response similar to the one illustrated in figure 5A. The light emitted by the LED board has 3 separate frequency bands visible as peak 601 for red, 602 for green and 603 for the blue frequency range. So going left to right, the colours are blue, then green, then red. It's a wavelength graph rather than a frequency graph. The important bit is that each emission is in a frequency band, such that there are gaps in the emission spectra between blue and green and red, and there's also unoccupied space to the left of blue and to the right of red. In the Claim, there is an implicit limitation on the predetermined frequency ranges. They are frequency ranges that are visible frequencies of light. Otherwise, they cannot fulfill the function required by the claim of displaying a moving image, for the purpose of which is to be visible to observers in the stadium. Moving on now to integer 12.2.
Sorry, say that again, Mr. Nicholson. Have I missed it? I can't see the word visible anywhere.
My lord, the words the word visible isn't there in the claim, but the purpose that's given to these emissions is configured to display a moving image on the display device in the real world by emitting radiation in one or more predetermined frequency ranges. And we say in the context of the teaching, which is that these displayed images are there to be seen by the spectators in the stadium. If the spectators in the stadium are to see moving images on the display device, then they need to be visible light images.
Right. Thank you.
So moving on now to integer 12.2, identifying camera parameters which calibrate at least one camera with respect to coordinates of the model. What this means is that the camera parameters allow the system to understand the relative position and orientation of the camera or cameras within the real-world space represented by the model. The camera parameters tell you what you need to know to relate the camera image to the model. They might include, for example, where the camera is positioned, where it's pointing, how zoomed in the lens is. This is conventionally referred to as PTRZ data, pan, tilt, roll and zoom data, sometimes telemetry data. It was typically captured by sensors attached to the TV camera and was part of the common general knowledge. Ultimately, the purpose of obtaining the data and calibrating it to the model is to allow the system at the later positioning step to work out whether, and if so how, the display device in the model is expected to appear in the images captured by the camera or cameras. We then move on to the capturing step at 12.3. This is the only part of the claim where images are required to be captured. The requirement is capturing at least one image with respect to at least one camera substantially at the same time, said at least one captured image comprising a detection image. Now, the at least one wording here is somewhat confusing, but it includes a situation where, for example, two synchronized cameras are mounted side by side, each capturing an image at exactly the same scene at exactly the same time, and with the same telemetry data. Each of the cameras calibrated to the model. So the claim permits, for example, one camera to capture a high-quality colour broadcast TV image, which is needed for broadcasting, and importantly will be the image to which overlaying is applied. And another camera specifically tailored to capture the detection image required later in the claim. For example, a specially filtered camera which captures grayscale images, which is used for the processing aspects of the claim, but is not intended to be shown to viewers. Now, we don't need...
Sorry, Mr. Nicholson, the at the same time language, maybe this doesn't matter, but if there's only one camera, what does the same time refer to?
My lord, we had that discussion at trial. I take no point on it. Where there's only one camera, your lordship...
What you mean is it really means there are two cameras, even though it says there's only one. The two at the same time.
Probably, but I take no issue with the fact that you may be able to arrange it in a one-camera situation and pull out a capture image and pull out a detection image. We don't need for the moment to think about what other camera setups the integer might encompass. Moving on, but staying within the claims discussion of the camera.
Before you move on from 12.3, I'm just struggling a bit with the language here.
Yes.
Capturing at least one image with respective said at least one camera. I don't entirely understand that.
Yeah, it's it comes in at 12.2 as the antecedent, because when we identify camera parameters which calibrate at least one camera, so it's the camera that we've calibrated to the model in step 12.2 is the antecedent to said at least one camera in 12.3.
I think what I understand 12.3 to be meaning is, if you strip it of some of the extra words, capturing an image with a camera. That's what the capturing an image with respect to a camera. I'm not sure what the respective is helping, but capturing an image with a camera is what that first clause is trying to say.
I think that's
right?
consistent with my position, my lord. Yes.
Okay.
Moving now into the important integer 12.3.1. This is a crucial aspect of the claim for this case. And this is the first time that the verb detect or detecting appears in the claim. Detecting is the word that appears in integer 12.5. In each case, the word is being used in its ordinary English sense to discover or ascertain the existence, presence, or fact of. As we shall see, the different claim integers are discovering or ascertaining different things, and they are not to be confused, elided, or amalgamated, which underlies much of the judge's error when it comes to construction. The integer 12.3.1 requires that the camera which captures the detection image must be able to do two things. First, detect radiation. Stop there. This is the first kind of detect in the claim. When a camera captures an image, photons of radiation hit a sensor and a signal of some kind is registered by that sensor. It is a physical process. These days the sensor will most likely be some form of photosensor divided into an array of pixels. The result in the language of the claim is the detection image. The claim carries on. The claim must be configured to detect radiation having a frequency outside all of the one or more predetermined frequency ranges. Here, the one or more predetermined frequency ranges is a back reference to integer 12.1.1.2, as clearly indicated by the use of the definite article, the. These are the frequency ranges which are emitted by the display device to display a moving image. So unpacking that, the camera that forms the detection image has to be sensitive to radiation other than the radiation used to display the moving images. Now, just to see what we mean by that, we can go back to figure 5b of the patent, which is, I've still got it open, it's in sub 1, page 20, sorry, sub tab 1. Figure 5b is reproduced from above, but the bandwidth of two band pass filters have been illustrated between the blue-green and green-red emission bands. As an example, the patent teaches that the camera forming the detection image can be equipped with a band pass filter so that its sensor only receives radiation at frequencies which are not being emitted from the moving, to form the moving image. And the second part of integer 12.3.1 requires that the camera forming the detection image must distinguish the detected radiation outside all of the one or more predetermined frequency ranges from radiation inside the one or more predetermined frequency ranges. Now this is all a bit wordy, but what it is driving at is that the detection image camera will form a detection image which excludes radiation used to display the moving images, but include other radiation. Ultimately, the idea taught in the patent and encapsulated in this integer of the claim is that the detection image excludes or filters out any information which comes from the moving image on the display device. As the patentee teaches in paragraph 34, lines 3 to 8, the image captured by this setup will not be influenced by any changes displayed on the LED screen. Therefore, due to the nature of the screen, the LED screen will have a uniform monotone distribution as if it was not active. What the camera is doing is removing the moving image information from the picture it is capturing. In the very simple example we discussed earlier, where the display has a white backboard and only red LEDs, the camera capturing the detection image needs to be able to detect radiation outside of the red range of frequencies emitted by the LEDs, but not the red LED light itself. What the detection image will show will be the billboard's backboard, all the surrounding scenery, but the moving red Coca-Cola logo, will simply not appear. And going back to tab 20 of the supplemental bundle and the ice hockey game, which is a slightly more complicated picture than simply just Coca-Cola, the image we will see will likely be grayscale, but in this one, assuming we filtered the red channel, the whole of the white billboard will appear light in colour. We won't see our Coca-Cola scrolling around the edges we've added. And put another way, it will be as if the billboard was not displaying any image, or to use the patentee's language in the specification, as if it were not active. And that's paragraph 34, column 10, line 7. There is no other limitation on what frequencies the camera can detect. The camera might be able to detect blue light, it might be able to detect green light, it might be able to detect infrared light. What matters is that the camera does not detect the radiation in the frequencies that are being emitted to display the moving image on the display board. Indeed, the patentee teaches in terms that instead of having the detection image camera sensitive to visible light in the regions between green, blue and red emissions, as shown in figure 5b, the camera can be sensitive to non-visible light. At paragraph 35, we are taught one can easily extend the method and apply the special spectral bandpass filter, that's the bandpass filter, the bits that the camera does see, in a range in the non-visible light. Also in this case, the captured image will not show any signs of the videos played back on the active screens. Again, the point that's being made is that the patentee's objective is to capture a detection image that excludes the videos. My lord. Any signs of the videos played back on the active screens. It filters or otherwise doesn't detect that which is being emitted by the display to form the moving images. Now, importantly, the camera does not have to be able to identify where the radiation it does detect comes from. It does not have to respond differently when it receives light reflected off of a player's shirt, or when it receives light reflected off the white background of our red LED board. It doesn't have to respond differently if the light is coming from an object in front of the billboard. Indeed, no known camera could do this. Cameras don't know what objects the light they detect is coming from. They just detect radiation and make a record of where the light has struck their sensor. And the patentee and the drafting of the claim is very aware of this issue. The claim does not say distinguish the radiation from the display device from radiation not from the display device. Such a claim would have massive sufficiency problems because the camera has no way of knowing where the radiation comes from. That is no doubt why the claim is framed in terms of the frequency bands of radiation emitted and not emitted to display moving images, and not in terms of the source of the radiation. Going back to our example in subtab 20, imagine we have our red LED display showing the Coca-Cola logo, and a simple grayscale camera which is filtered to exclude all red light. Because the frequency range emitted by the LED display is red, that's why we're filtering it. Now, as it happens, there are quite a few players with red clothing occluding the billboard. There's the arm of the player closest to the referee with the 55 on his back, and the 12 on the back of the player behind him has an arm that's red, and the body of the player in front of the Modell's sporting goods logo has got substantial red on him. If you were to look at the detection image from this camera, you would notice three things. Firstly, the Coca-Cola logo, which we've assumed is being displayed on the board, would not appear at all, because the red LEDs only emit red light, and all of that light was filtered out before it got to the camera. The billboard would look as if it was not active in the detection image. Secondly, the billboard itself would appear to be a light grey block. It has a white background in real life, so it reflects all the colours from the ambient light illuminating the stadium. Filtering out all the red light from the rainbow still allows reflected blue and green light to get through the camera sensor and register an image. It will just be as plain as the background of the billboard. Thirdly, the bits of the player that are red will appear in the image. This is because, unlike a red LED, fabric and the like doesn't give off pure red light of a specific frequency. As the patentee expressly teaches in paragraph 34, column 10, 8 to 11, that in contrast to the monotone nature of the display emission, since real-world objects have very complex frequency response curves, they are still visible in the captured detection. What the complex frequency response means is that the shirt reflects a continuous spectrum of wavelengths. Red most strongly, which is why we perceive it as a red shirt, but the colour we see also includes some lesser amounts of blue and green, which is still represented in the detection image. And of course the shirt will probably appear to be relatively dark, but it would still be visible in the image, and if you looked at the image closely, you would be able to see most, if not all, of the detail, such as creases on the shirt, shadows falling in the shirt, and so on. At the extreme, if the red was precisely the pure red of the display LEDs, features such as the 12 and 55 on the back of the shirts would appear black in the image, which would still be a significant contrast against the white top. We would still see the numbers 12 and 55. And whilst we're looking at this picture, the referee's trousers, who's up to the top middle of the screen, which are jet black in the colour image, would still be jet black in the filtered grayscale detection image. That's because the black arises because of a lack of radiation being reflected by the black fabric across the entire visible light spectrum. They would not, and they could not, become bright or light in the detection image simply because we filtered the red component out. You can't create light for the camera to see. That brings me to step 12.4, positioning the overlay surface within the said at least one captured image based on the model and camera parameters. This is a step where the system takes the model from integer 12.1 and the camera parameters from integer 12.2 and calculates where in the captured image the billboard is expected to be positioned. So if the camera is pointing at a rectangular billboard from a perpendicular direction, the billboard will be expected to appear as a regular rectangle of a particular size in a particular position within the image. And if the camera angle is more complicated, the shape, the size and position will change similarly. This is a fairly simple process, dare I say, of 3D modelling and perspective. The experts agreed it was all well within the common general knowledge. Note here that the positioning step does not require any inputs other than the model and the camera parameters. It does not require processing of any image itself to try and find the billboard. The expected position of the board is mathematically calculated within the model based on the model itself and the camera positioning information. That brings us then to integer 12.5. detecting an occluding object, at least partially occluding the overlay surface, in a selected camera image of said at least one capture image, based on an image property of the occluding object and the detection image. As elsewhere, this claim integer is complicated by the possibility of multiple captured images. But if we strip out that complexity, what you end up with is detecting an occluding object, at least partially occluding the overlay surface in a captured image, based on an image property of the occluding object and the detection image. And here we get to that second instance of detecting. One's detecting, the other's detecting, but the words are the same in the claim. Again, it takes its ordinary English meaning to discover or ascertain the existence, presence, or fact of. But here, we're not detecting radiation, we're detecting an occluding object. In contrast with integer 12.3.1, where we were detecting radiation. 12.3.1, the requirement to detect radiation is the physical process of using a camera. There is no concept of an object in the context of 12.3.1 at all. In contrast, 12.5, there's no concept of radiation. We already have the detection image from the camera and the captured image insofar as that's different from the detection image. What this integer requires is the detection of an object. Using the digital detection image in conjunction with an image property of the occluding object. This is not a physical process at all. It is an image processing step to check whether the particularized information, the image property of the occluding object, is present in the digital file, and if so, identify where it is. The image processing step has nothing to do with detecting radiation. It's carried out by applying a computational algorithm to a digital file, ultimately just a collection of ones and zeros. Both uses of detect in the sense of to ascertain the existence, presence, or fact of are perfectly conventional uses of the word detection or detect and apt in each case. But that doesn't mean that the detection integers are interchangeable or amalgamated or can be elided. It doesn't merge the two processes into a single detection, nor does it justify treating them interchangeably. They're quite different parts of the patentee's process. And this is all the more so as the detecting step at 12.5 requires that the detection occurs based on an image property of the occluding object and the detection image. An image property of the occluding object is a property that defines an occluding object in such a way that the detection algorithm can identify the presence or not of the object in the detection image. So a very simple example, footballs are round and might be expected to occlude the billboard during a football match. In the simplest way, you might define the image property of a football as being a contiguous round region of pixels. The algorithm would process the detection the detection image and look for a contiguous group of pixels in a round shape. If it finds such a group of pixels with that image property, it determines it to be an occluding object. Now we'll come back to the term image property of an occluding object in due course, but what integer 12.5 is about is image processing the detection image, at least in the area where the billboard has been calculated to be, to find or detect objects which are occluding the billboard. And the patentee spends the whole section of the patent from paragraphs 36 through to paragraph 43 introducing three algorithms for this sort of object detection, immediately after having taught how to deal with moving image displays at paragraph 34 and the use of a real-world model to find where you are in the image at paragraph 31. We pause briefly to acknowledge that the algorithms for finding a football or a person in a digital image and how to define the necessary image property of each such potential occluding object might initially sound like a very complicated task. Indeed it is, and our simplified example of finding a round football is exactly that, incredibly simple to illustrate the principle I'm talking about. But it was common ground at trial that the necessary algorithms were part of the common general knowledge. The concept of detecting occluding objects using spatial frequency differences in techniques is introduced from paragraphs 36 to 43 of the patent, as I've said. There are at least 3 broad techniques discussed. Both experts considered these paragraphs to be at a high level, and both accepted that the algorithms would be CGK, and neither suggested that spatial frequency techniques or higher order processing techniques, as tended to be the term that was used at trial, of this sort could not be used by the skilled person to detect objects in the way the patentee suggests. Indeed, what can be done with image processing is sometimes surprising to the layperson. We're some 9 years on from the priority date, but for several years now, the mobile phones in our pockets have had no problem whatsoever in finding people's faces in digital images. Those working in image processing know how to describe image properties of a generic person or a generic football, and they can design algorithms to find people using property descriptors quite reliably, even in fast-moving still images from a football game. It's complex stuff, but routine work for those working in the area. And then finally, finishing the claim at step 12.6, overlaying a non-occluded portion of the overlay surface with an overlay image. By overlaying the moving image displayed on the display device in the real world with the overlay image in the selected captured image. Note that it's the non-occluded portions, not the visible billboard portion, which is being overlaid. The claim integer as a whole is easy to understand. We know where the billboard is from calculation. We found any occluding objects, and we can change the image corresponding to the non-occluded portion of the billboard. Indeed, as the patentee teaches in paragraph 13, column 4, line 19, talking about his apparatus, the overlayer 10 determines the non-occluded portion of the overlay surface in the captured image by combining the outputs of the positioner and the detector. The overlayer replaces the non-occluded portion of the overlay surface by an overlay image which may be pre-stored in storage or which may alternatively be alternatively received via another video interface.
Mr. Nicholson, you said
Sorry, my lord.
You said note that it's the non-occluded portion, not the visible billboard portion, which is being overlaid. And I think I understand what overlaying the non-occluded portion is, but I don't understand the distinction you're trying to draw.
Well, the distinction is that the way in which the patentee is defining what he's going to overlay is he knows where the billboard is and he's overlaying the non-occluded position. So he's finding the occlusions and he's doing the subtraction as he teaches. Right. And I say that's distinctive to saying overlaying the still visible portions of the billboard. It's a small point of language, but the way the claim works throughout, the way the patentee teaches his method is find the billboard using the positioner, use an algorithm to find the occluding objects, and then overlay the non-occluded bits. He doesn't say, look for the bits you can still see of the billboard. That's a small distinction.
That's the point you're trying to make.
Now, as we've viewed the claim, now Dr. Thomas made clear the concept taught and claimed in the patent is not the billboard signature system. It does not find the overlay surface by looking for the signature of visible parts of the billboard within the detection image. To the contrary, it purposefully excludes radiation emitted from the billboard from the detection image. The only radiation being emitted from the billboard that's discussed anywhere in the patent is that for the moving images. That's the information which is referred to in the claim as is excluded from the detection image. Instead, the patentee detects occluding objects, determines the necessary overlay by excluding occluding objects from the region of the image calculated from the 3D model and camera parameters as corresponding to the billboard. Put another way, in the patent, the billboard is found by calculation and the objects are positively detected. And the patentee makes this point expressly in paragraph 27 about his object detection system. In sub-tab 1, paragraph 27 of the patent, which is on page 5 in the blue, 4 of the original patent. As the board itself is not needed to position the overlay surface in the selected image or in the detection image, nor to detect the occluding object, it is also possible to define one or more overlay surfaces in the model 5 of the real-world space, which do not exist as any physical surface in the real world. Such an overlay surface may be called a virtual surface. So what the patentee is contemplating here is that I can define that column of the court to be an overlay surface, and in my digitally replaced image, insert advertisements or other information in the televised image, even though there's no display there at all in the real world. Now, the claim requires there to be a physical overlay surface. Absolutely no doubt about that. We looked at it, display device. But the patentee's general teaching that we're looking at paragraph 27, where he's explaining more broadly how his method works, says, in my system, you don't even need a display. I can look for occluding objects because I detect occluding objects separately to anything coming from the display. Now, in the contrasting billboard signature system, the visible parts of the billboard are found directly in the detection image based on their distinctive signature. There is no concept of detecting an occluding object as such. The physical billboard, which has a special signature, is absolutely essential to the overlaying operation. The only thing which the system knows about, the only thing it's able to positively identify is visible billboard using the billboard's radiation signature. And that is why Dr. Thomas rightly says that a billboard system and the patent are conceptually and technically different, even though they end up doing substantially the same job. So that's the overview of the method of Claim 12. It's somewhat laborious and wordy, but the scope of monopoly is clear and corresponds with Ames' experts' evidence and the patent's teaching as a whole. We appreciate that we've gone through the claim rather than the patent's teaching, but at paragraph 7 of our appeal skeleton, we've directed, my lords, to the very much the same discussion of the patentee's system in our opening skeleton from trial, with all the references to the description. For my lord's reference, the extracts from our opening skeleton are all in supplemental tab 6. And I can pick up the patent section at page 110 of the bundle, just to show you what we've done. What we do over the next 7 pages or so is go through the textual description from the body of the patent, which describes how the patentee's principal drawing of the system, figure 1 works, adding commentary as we go. Now, I'm not going to go through it again now, but I do commend it to my lords as being wholly consistent with what we've ended up saying, what we say ends up in Claim 12, and as I've described to my lords this morning. Now, before we leave the patent Claim 12, it's perhaps helpful to point out what the patentee is actually doing and why. And we can pick this up in our appeal skeleton on page 6, I think my lords have it in the supplemental bundle, but I have it, oh sorry, in the core bundle. I have it separately. And it's page 25 of the core bundle. This is our Where's Wally example. Now the patent's teaching is that by eliminating the changes on the billboard from the moving images, but retaining the foreground image of any occluding object, you can facilitate the object detection process. What the patentee teaches at paragraph 34, column 10, lines 4 to 15, is that the image captured by this setup will not be influenced by any changes on the LED screen, and therefore, due to the nature of the screen, the LED screen will have a uniform monotone distribution as if it was not active on the capture detection image. Since occluding objects, typically are real-world objects, and have very complex frequency response curves, they are still visible in the captured detection image. Changes between the static background and moving foreground can be fed into one of the algorithms to compute the occluding object based on the properties of the occluding object and/or of a background model. Now, we illustrated this at trial with Where's Wally, which was put to AIM's expert, Dr. Thomas. As far as my lords don't already know, well, Where's Wally is a children's game.
I think you can take it, we know.
I'm very grateful, my lord. So, in the top left-hand corner of the 4 mini pictures on page 6, the reason that Where's Wally is challenging is that Wally gets lost in the noise of the rest of the picture, making his defining properties difficult to spot. And what the figure on page 6 demonstrates is that spotting Wally is considerably easier, dare we say simplicity itself, if there's a way to remove the background and, as taught in the patent, replace it with a background which is uniform and monotone. That is what we show in the 3 sub-figures. Bottom left, white, top right, black, bottom right, grey. That's what the patent does. The visual noise from the moving images on the billboard, which potentially make finding a foreground object, an occluding object, very difficult, is to remove them. The filter detection image removes the noise, rendering the billboard in the detection image monotone and uniform, as if it was not active, yet continuing to show the foreground objects. And that makes the subsequent object detection process, undertaken by algorithms to compute the occluding object based on the properties of the occluding object, much easier. And we discussed this with Dr. Thomas, and he agreed, as we see in the images, on page 6. It doesn't matter whether the billboard's representation in the detection image is white, black, or grey. What matters is its smoothness compared to the occluding object, or rather it being uniform and monotone is what the patent teaches and what is required to implement the patentee's system. As we note in paragraph 18 of our appeal skeleton, Dr. Thomas's only caveat to our Where's Wally example was that he might prefer the billboard in the detection image to end up being either very black or very white, rather than some mid-grey. That is all.
Mr. Risco, I understood this much. The way it's removing all the busyness is because the busyness is all inside one of the predetermined frequency ranges.
That's right, my lord, yes. So whilst my lords have our skeleton open, in paragraph 18, which is on the next page, tab 7, I should point out there's a transcript reference error. The T2 132, the last reference in bold on the page, that should be within the previous bigger section, and it should be T tab 1, page 142. I apologise for that error. Does my Lord Justice Burris have that?
Nope.
Sorry. It's page 7 of our skeleton, paragraph 18. 5 lines up from the bottom, there's we say, and particularly T2 132 to 143. It should be T1 142 to 143. My Lord, that brings me to the Nevity prior art, and we can pick up the disclosure of the Nevity prior art in the supplemental bundle at tab 2 and page 46. This is Nevity's figure 3 that was used at trial and is picked up in the judgment as giving a reasonable overview of Nevity. In the top left, Nevity shows a footballer in front of an advertising billboard, partially occluding it, but displaying the word sport. A picture is taken here using two synchronized cameras. They're shown bolted together as 20 and 60. The top camera, 20, takes a normal TV image, which is represented by the illustration on the right-hand side, 21. It's got all the same real-world properties as the illustration in the top left. The second camera, which Nevity calls a detector, takes a second image, which is shown on the left-hand side, 61. Now, what isn't disclosed in this diagram, but which is taught in Nevity and was common ground at trial, is that the whole surface of the billboard in Nevity is equipped with a constantly on infrared emitter array, lighting up the whole of the backboard. And the detecting camera 60 is an infrared camera that filters out visible light, detecting radiation only in the infrared band. So the resultant image at 61 is something of a silhouette, in which the billboard appears very bright because it's emitting strong infrared, but everything surrounding it and any regions which are blocked or occluded by objects appear darker. That is because compared to the strong emission of infrared from the billboard, there is relatively little infrared light in ambient sunlight and even less in artificial light. It's a billboard signature system, rather like green screen, but the signature is in the infrared band rather than the visible green spectrum. Going back to the diagram, in the middle between the TV image and the detector image, we have PRTZ, pan, roll, tilt, zoom data from the camera, informing the system where the cameras are being pointed. The signal processing unit, 45, and the mask signal generating unit are used to form a mask signal, which we see at 43. It appears simply as the inverse of the signal at 61, although Nevity also teaches that the border around the billboard can optionally be enhanced by using the PTRZ data and knowledge of where the billboard is in the real world. Over on the right-hand side, there's a storage element towards the bottom, 49, from which the alternative advertising, here depicted by the word other, is exemplified, which is then fed into the image selector unit, 48. Using the mask, the TV image 21, the content substitution unit swaps parts of the image corresponding to visible billboard for the corresponding part of the alternative advertising. In the mask, the bits of the image that are black are the visible billboard, and that is what is overlaid. Everything else is left unaltered. So coming out of the bottom of the system at 41 is the overlaid TV image, and we see that the word sport has been substituted to now show other, and the occluding player has been avoided, but was never detected as such in the system. The system goes out to look for the visible billboard. Now, Nevity doesn't disclose a billboard displaying moving images. It is largely silent as to the implementation of its system, because its focus is actually about how to choose the best advert to replace the one that you're taking out. What is being displayed in the on the display advertisements doesn't matter to Nevity, because it doesn't attempt object detection, and all the signature work is done in the infrared band using an infrared camera. However, it was common ground between the experts that using Nevity with moving image billboards at the priority date was obvious. It doesn't actually require any change to be made to the system at all, save for the installation of the new billboards, and the judge recorded this position on obviousness in the judgment at paragraph 26. It's common ground, it's a billboard signature system, and we can test that by imagining turning off the infrared signature. At this point, there is nothing to detect. The entire scene has varying levels of infrared light dependent upon the amount of ambient infrared light. And looking at figure 3, the bright board, whether or not occluded, will have disappeared in the detector camera image 61. All of those bright pixels that are shown white in 61, once you've turned the billboard off, they all go black, and the entire mask is black. As with the patent, I've taken the description of Nevity very quickly, and I can do so because what it taught was not really in dispute at trial. Again, my learned friends, my lords, have a detailed written walkthrough of Nevity's teaching, centred on the figure 3 we're looking at, using Nevity's own written description with additional commentary in our opening skeleton that we've cross-referenced, and it's in sub 6, 146 to 163. I can see my juniors. The SVB system, I can pick this up quite quickly from the diagram in the judgment, which is at core tab 8, page 123. This schematic only shows the logic flow of the masking process in the SVB system. It shows how the system picks out pixels which do not have the unique billboard signature that the SVB system looks for. If the logic test is satisfied in either of the two branches, the top branch feeding into the OR gate or the bottom branch feeding into the OR gate, the system knows that the pixel is not a visible part of the billboard and should not be overlaid. What it's not doing is identifying occluding objects. It ends up with the same mask as Nevity, but just like Nevity, it's wholly based on looking for a signature of the billboard. It knows about the signature, it knows nothing about the properties of any occluding object. To explain, once the mask has been generated, the image substitution in the television image takes place in materially the same way as Nevity and the patent. The mask is shown figuratively on the right-hand side of the diagram using the same exemplary images that we just saw in Nevity of a footballer in front of a rectangular screen. The SVB system is an enhancement to Supponor's own Nevity system. It differs from Nevity in that instead of using a single channel infrared signature to identify the billboard, it uses a dual channel signature. The first channel, which is shown in the top black section of this diagram, is identical, or materially identical, to Nevity. The board emits a constant, strong, short band infrared signal, which is picked up by infrared camera 1. And we see that being represented by the image on the top left with the grey or dark object and background and the very bright billboard. The system operating on the top channel looks for pixels which are part of the visible billboard, identifying them because they are very bright in infrared channel 1, just in Nevity. Again, as with the option in Nevity, camera PRTZ signal and a model are used to improve the quality of the selection, and that's the section in blue, the camera parameters and the model feeding into the black and green boxes. The PRT's data model are used as a Nevity for sizing and shaping the overlay image appropriately. Now, the SVB system can be operated in this way, in which case it operates just like Nevity. And it's in that mode when the switch that's shown at the bottom of the OR gate is in the open position. What you're left with is Nevity. Now, not surprisingly, AIM accepts that in this mode, the SVB system does not infringe. The SVB system, however, has an improvement feature over Nevity, which can optionally be used by closing the switch depicted in green at the lower input of the OR gate on the figure. One of the problems with Nevity, for what it matters, both experts agreed upon, was that in very bright sunlight, reflected infrared from occluding objects can reduce the contrast between the light coming from the object and the strong infrared light being emitted from the billboard, which can make finding the bright billboard signature less reliable. For example, in very bright sunlight, a highly reflected object may lead to pixels with a high level of brightness, close to that expected for the signature of the billboard. And Supponor's solution is to install a second infrared channel, supported by a second infrared camera. And that's what we see on the bottom section of this diagram. Infrared channel 2 uses a different frequency range to infrared channel 1, but still within the infrared region of the electromagnetic spectrum. And just pausing there, to the layperson, it's easy to think of the visible spectrum with all its colours in and infrared. In fact, infrared has got a spectrum within it, much like the visible spectrum. So you can have different colours, if I may call them that, in the infrared. And what's going on here is the top channel infrared is at a different frequency band to the bottom infrared, but they're both still in the infrared part of the spectrum, the part that we can't see. Now, in addition to installing this additional camera, Supponor's billboards are specially arranged to be very absorbent of infrared, as well as emitting a strong infrared 1 signal. Infrared camera 2 is sensitive in infrared band 2, but not in infrared band 1. Now, putting that all together, the result is that the billboard, when you can see it, should always look especially dark in infrared channel 2 when viewed with camera 2, and especially bright in channel 1 when viewed with camera 1. And this is illustrated in the two pictograms on the left-hand side of the drawing. You see in the top one, the billboard very, very white. In the bottom one, the billboard very, very black. And then everything else is whatever it turns out to be, some grey level in between. In the new second channel, the surrounding environment and any foreground objects will be illuminated by the ambient light and could take any appearance depending on how much infrared there is in the ambient light and the infrared characteristics of the fabrics comprising the objects. An object might be light, it might be dark, or it might be somewhere in between. In channel 1, except in very strong sunlight and with very reflective objects, the billboard will always be different. It will be brighter than anything else in the image. That is not true with channel 2, where the billboard is dark. And the reason for that is there's nothing the system can do to make no radiation a characteristic signature of a billboard, which is unique to the billboard. Any object which absorbs infrared light, whether it's illuminated by infrared light or not, will appear dark in the infrared 2 camera image. And that's why infrared channel 2 is never and can never be used on its own, because the signature of the billboard, very dark, cannot be made unique to the billboard. What infrared channel 2 does is enhance the signature of the billboard, making it more distinctive when and only when used in combination with channel 1. True visible billboard should always have very bright in channel 1 and very dark in channel 2. In other words, where a pixel corresponds to visible billboard, there will be a high ratio between the signals from the two channels and a high signal level in channel 1. Anything else, so any other object or thing or something that appears in the images, should not have this artificially created infrared signature. Even in cases of high ambient infrared light, an object that reflects in infrared 1 is and is therefore bright in channel 1, could be expected to be similarly bright in channel 2, because the wavelengths used for the two bands are very close together. The result is that the ratio between the two channels for non-billboard pixels will be low, whatever the absolute value of the infrared light might be. Now, this does not mean that the pixel is being detected as an occluding object. It means that the pixel does not have the characteristic signature of the billboard. The SVB system operating with both channels still goes about finding pixels based on the signature of the visible parts of the billboard. A pixel is not overlaid in image replacement if its signal in IR1 is too low, or if the ratio is too low. Breaking that down, a pixel seeing radiation from the billboard is expected to be bright in the first channel emitted by the billboard. Now that never changes. So if the pixel brightness is too low, the system can say with certainty that it isn't looking at a visible part of the billboard. And a definitive decision can be made of not billboard, irrespective of anything that happens in IR channel 2. That's how Nevity works. But where there are high levels of ambient infrared, such as bright sunlight, it's possible that non-billboard objects might be reflecting infrared at a relatively high level, so that the difference in IR channel 1 between strong signal you get from the billboard and the reflected signal isn't consistent. May see a pixel with a brightness which is consistent with it being part of the visible billboard, in which case IR1 could wrongly overlay the pixel. But the system's decision-making can be improved by additionally looking at the contrast between the two channels, where a visible billboard pixel is expected to have a high ratio between IR1 and IR2, because that's the special signature of the billboard used in the system. In contrast, any non-billboard object is very unlikely to have this special artificially created sudden step change in infrared frequency response used as a signature. If something reflects highly in channel 1, it very likely reflects highly in channel 2, and the same goes for absorption. So when IR2 is being used, the system will only consider a pixel to be part of the visible billboard when the complete signature is present. Both signature components are satisfied, bright in channel 1, dark in channel 2. Every other combination is rejected and treated as non-billboard. The second channel signal is never used on its own. It cannot be, as it's meaningless without a comparator with channel 1. The information is only useful when contrasted with channel 1, because no infrared in the second channel band is generated as part of the signature of the system. The IR2 signal depends entirely upon the ambient level of infrared, which is unknown, and the reflective properties of everything in the scene, which is unknown for everything other than the billboard. As will be apparent, the amount of infrared received by camera 1 and camera 2 from any object will depend upon the amount of ambient infrared light and the reflective properties of the object. In both IR1 and IR2, objects may appear anything from exceptionally dark if there's no ambient infrared or the object is very absorbent in the infrared bands, to extremely bright if there's a lot of ambient IR and the object is very reflective in the IR bands. As my lords will no doubt appreciate, any moving images on a billboard display will be in the visible band and not picked up by either of the two IR cameras. It's not part of the design, it's just because the system and its two detectors are operating entirely in the specific infrared bands and have narrow infrared band class filters. The SVB system is a fully billboard signature system. The system makes no attempt whatsoever to find or detect occluding objects. It is purely configured to find visible parts of the billboard based on either on the simple single channel signature disclosed in Nevity or the more complex dual channel signature contrast approach of the SVB's second channel. The fact that this remains a signature system can also be tested by turning off the infrared 1 emitters in the billboard. At that point, everything in the image will be determined to be not visible billboard, just as in Nevity. And that is true whether one or both of the IR channels are in use. And this occurs because without the infrared emitters, the infrared contrast signal of the billboard disappears. And the Nevity-like brightness signature also disappears.
So on this point, is your submission that the decisive error that the judge makes is at paragraph 164 of the judgment, where he says that on the SVP system, IR channel 2 processing can be decisive in assigning a pixel as being part of an occluding object, when channel 1 processing would say that it was not, because you say that IR channel 2 is decisive as assigning a pixel as coming from the billboard.
My lord, I'm grateful for your lordship taking me to that point. At trial, we said it was inappropriate in a method claim to look at part of the system and read it in isolation. That point, which the judge is dealing with in paragraph 164, I am not taking on this appeal. My point is one purely of construction, but it's against the background that what we're looking at is, I want my lords to see the complete system, to see how it's working and how it's working as a signature system, so that when the judge ends up with a construction in an object detection system that somehow, by looking at part of it, is said to infringe an object detection system, something has gone wrong on construction. So it's a construction point that comes over, rather than a complaint about the way the judge looked at a partial part.
Well, you've said so far that looking at the occluding object...
I'm sorry, Mum.
You've said so far that looking at the occluding object is fundamentally different from looking at the billboard.
I have.
And I just wondered if that was where you said the judge went wrong on infringement. But that
is where I say he's gone wrong on infringement, but not in the partitioning of the system to have infringement only by the second channel.
Yeah. Okay. Thank you.
Ms. Nicholson, can I make sure I've understood the diagram in the judgment that you'll be taking us to? I'm about to say, this isn't actually why I was going to ask the question, but just in case, I just want to make this point so you're aware of it. I didn't find this OR gate very clear, but that's not actually what I'm asking you about. But just so as you know, I don't find that OR gate very clear, but I don't think it matters very much. But if it does matter, then you might need to explain it again. But the question I wanted to ask you was, what's going on, as I understand it, if I'm looking at the bottom, the green, well, it's not just green because some of it's in blue, but the lower bit of this, the IR image 2 aspects.
Yes.
You've got, starting from the left, you've got IR image 2 from second IR camera, and there's a little picture.
Yes.
Then, if we follow the green arrow from IR image 2, we come to a big box, which has 2 green arrows coming into it, which is, and the point that's being made, as I understand it there, is that the lower arrow depicts that what's happening inside that box is taking into account information from the second IR camera, and the upper arrow is making the point that it's taking into account information from the first IR camera.
Yes, fine.
That's what you're explaining. And if we look inside the box, it says in blue, okay, I'm not worried about the colour, of the pixels corresponding to the area of the expected board position. Now just pausing for a second there, because it hadn't dawned on me till I was listening to you what the significance of that. When it says of the pixels corresponding to the area of the expected board position, what that means is that the decision making or processing, if you will, that's going on, that's described in that box, is looking at each of the pixels inside the rectangle which corresponds to where it thinks the board is going to be, and that includes the pixels which in this particular version are black, and also the pixels which are the legs of the figure. It's all of them.
Looks at everything.
So, yes. So it is looking at the pixel, at what is detected in the detection of radiation sense of the word detected. It's looking at what is detected from the legs of the person, the occluding object. That's what it's doing, isn't it?
It's taking the array of pixels from both images and forming a pixel by pixel contrast for every pixel in the image.
Exactly, but just to labour it, just because I listening to you, I thought, I got the impression, and I realised it was wrong, and that's why I'm just labouring it slightly, because I want to make sure I've not misunderstood. It would be a mistake to think that the only thing that's happening is it's looking at the pixels which relate to the background, to the bit where the board is, but not the person. It's looking at all of them.
Your lordship's right. It's looking at all of the pixels in the image.
Yeah, yeah. And then what it's doing is comparing the brightness, the intensity, in a given pixel of what's coming out of image 1 and what's coming out of image 2. That's what it's doing.
Oh, yes.
Yeah. And the point is that by having these two cameras, where the in the top case the board is very bright because you've actually got some way of emitting infrared radiation, which of course the human eye doesn't see, but it was as if it's a very bright light bulb, and that's what's described in the top. Whereas in the bottom, it's not emitting this infrared light, and so you get a very high contrast between the two pixels when you compare them, and that's how you can tell that it must infer that it's the unoccluded bit of the display board. Whereas when it's the person, the point is that the relative strength of the infrared coming in that pixel from the top and the bottom is about the same, crudely, and therefore you're identifying that as the occluding object, not the unoccluding object. Now you say, I understand, you say, oh no, we don't detect occluding objects. I get that.
Yeah.
But what you do is compare the intensity of the pixels in what us sitting in this courtroom, godlike, looking at this, can see is the occluding object. That's right, isn't it?
And the point we make, your lordship gives all the caveats and all the warnings to me before you say no. If you turned off, accidentally there was a fault, you turned off half of the display.
Sure, it wouldn't work.
It wouldn't work. Because what you're really looking for is not, you're looking for that signature of the billboard. That's the only thing that matters.
But when you're doing the thing which uses the second camera, you are doing something with infrared radiation which has been detected from what we know is the occluding object.
You are absolutely, my lord, but just to make sure that we've completely understood it, you're doing exactly the same, all pixels, in the top system as well, because in the top system you're looking for the level of signal from every pixel. Some of those pixels will relate to the billboard and we'll see them at a very bright level. Yeah. Some will come from the occluding object and they'll be at a much lower level. Yeah. So you are looking, in both cases, you're looking at...
So if we're doing it without the red-green one, we're just doing it on its own with infrared camera 1. Again, you look at all the pixels inside the rectangle.
Yes.
And the ones that are very bright, you say that's billboard, And the ones that are less bright, you say that's footballer.
Not billboard. Yeah. And the point my learned junior makes is that if the object is very dark, very absorbent of infrared light, it will be black in both of these two images. But the system will be able to still find the billboard because it doesn't care whether the object is very black in both images or very bright in both images or some mid-tone in both images. What it cares about is that characteristic signature of the billboard, which is the only thing in the entire scene which is high in one channel and should be low in the other channel. That's the only thing the system knows with certainty it can have as a signature. It's the billboard. It knows nothing about what it's going to get from the object. My lords, that moves me on to just a very brief summary of Ames construction. We'll obviously get to Ames construction as accepted by the judge and how they managed to sell it to the judge in due course. But the essence of what my learned friends say is that they have to construe the claim so that in addition to covering an object detection system, which calculates the billboard location and then does object detection based on the image properties of an occluding object, because that is what the patent teaches. The claim also covers a billboard signature system, which doesn't have any object detection algorithm based on image properties of the occluding object in the real world at all, but instead simply searches for the signature of the billboard. At the very best, it is based on the image properties of the billboard, we say, where the detection is being done, that the system looks in the detection image, for those pixels that have the image properties of the billboard rather than the image properties of the occluding object. Now, AIM had no choice but to so argue, because the alleged infringement, my client's SVB system, doesn't have object detection. It's a pure signature system. It knows nothing of the image properties of objects. All it knows about is the image properties of the billboard, the signature. And if one thinks that construction challenge might be difficult, it got even more so. And that's because, as we've seen, the prior art Nevity is also a billboard signature system. It too knows about the image properties of the billboard and nothing else. So AIM was faced with having to construe its claim in such a way that it was broad enough to cover billboard signature in the alleged infringement, but somehow exclude the otherwise invalidating billboard signature prior art. And the idea they came up with and somehow managed to sell to the judge was that the claim, properly construed, is limited to a system which generates detection images in which the billboard must always appear dark and the foreground object must always appear light. A claim to a so-called light-on-dark system, the light being the objects on the dark background. Thus, says AIM, this can read onto the dark channel of the SVB signature system, which we don't accept, but not onto the dark-on-light Nevity signature system. And as we'll come to explain in the context of our specific grounds, AIM's construction does not reflect the patentee's teaching. It only arises by confusing and eliding detecting radiation in integer 12.3.1 with detecting occluding objects in integer 12.5. It also requires a significant glossing of the claim with assumptions about the preferred embodiment which are not explicitly disclosed anywhere in the patent. It requires the entire detecting to take place in the camera with nothing being left to be done at integer 12.5. And insofar as 12.5 is being considered at all, ignore that the actual detection in the subsystem is looking specifically for the signature of the billboard and not the image properties of the occluding object. And the extreme nature of AIM's case before this court, as it was before the judge, is well illustrated from what my learned friends say in their skeleton, which is in core tab 4, paragraph 9, my learned friends say, discussing the patent generally, the patent takes a different approach. Rather than detecting infrared from an infrared emitting billboard, which would have to be specially designed, manufactured and installed all around a stadium, like the SVB systems boards, the invention enables detection of the occluding object itself by exploiting a particular feature of ordinary RGB LED billboards. It then uses the presence of the occluding object, such as a player, at that point to indicate where there should be no overlay. I'm just pausing there. Using a feature of an ordinary RGB LED billboard is completely incompatible with the patentee's express teaching that no billboard is required, including to detect objects, paragraph 27 of the patent. It also relies on an alleged feature of an ordinary RGB LED billboard, which was not common ground at trial, and more particularly is never mentioned anywhere in the patent itself, including the claim. The description doesn't need a billboard, and the claim calls for a display device with certain configuration properties that makes no mention of the feature that my learned friends are here saying is the crux of the invention. There's no mention of ordinary, no description of ordinary, no limit to RGB, quite the opposite. One or more predetermined frequency ranges, and no mention of LED, where paragraph 26 tells us that the invention is not limited to LED technology. Skipping over some newly annotated drawings, where my learned friends seek to argue for the first time that although presented by the patentee as emission spectra, those drawings would actually be viewed as emission and reflection spectra. We reach paragraph 12, where my learned friends seek to represent the interpretation of the patent's teaching as follows. Put another way by analogy, if one puts on special filter glasses which block the light from the frequency bands emitted by the LED billboard, the screen will appear black. However, an object in front of the billboard that emits or reflects light in wavelengths in the gaps between those peaks will remain visible. So in the diagram, the player can be seen, can be thought of as any frequency of light that can be detected, even if the peaks 601, 602 and 603 are filtered out. But this leads then to the conclusion at the end of paragraph 13, that the consequence of such use of a frequency selective camera is therefore that the pixels in the camera image which correspond to occluding objects should be light, and pixels which correspond to the area of the billboard should be dark. Well, straight to my learned friends, this is complete nonsense. The patent is not about a frequency selective camera, which frankly is what their construction comes down to. If it were, then it would be anticipated by Nevity, which has its own frequency selective camera, tuned to the IR emitted by the billboard. That's how Nevity works. Perhaps more importantly, the notion at the end of paragraph 13 does not make any technical sense. If my lords could go back to the supplementary bundle, dare I say one more time, but it's possible I'll go again. Tab 20, the ice hockey match. My learned friends are presenting their example in the context of figure 5 and the visible light spectrum discussed in paragraph 34. And it's therefore convenient to continue to think in the visible light spectrum. Now, no filtered visible light camera in the world could possibly filter this image to make the black trousers on the referee appear bright. They are visibly black because they do not reflect any light anywhere in the visible spectrum. Filtering the image may make them appear even blacker, if that were possible, but the idea that if the background billboard is arranged to be black, the special filtered camera will make all foreground objects be bright is just wrong. Yet this is precisely the core of the arguments that my learned friends are left trying to run in an attempt to represent the clear teaching of the patentee as nothing more than a filtered camera, in which the billboard appears dark and the foreground objects light, in order to read onto the one feature, the dark billboard camera, that the SVB system has that Nevity does not. What the actual patent is teaching, how it works, and what has in fact been claimed, has been entirely discarded. Now that, my lords, finishes the overview of all of the technology, how we see the patent, how we see Nevity, and how we see the SVB system. The facts that I've sought to go over have not been contested by my learned friends. They were common ground at trial. And it's against that backdrop we can then go to the specific areas that we raise in our grounds and show where things went wrong. Picking up Group A, the construction grounds first. Ground 1 is that the judge was wrong to construe Claim 12 to include detection by pixel brightness assessment. Our position is that it requires real object. The claim integer 12.5 requires real object detection. The term that was used at trial was higher order processing. It needs to be using image properties of the occluding object. I emphasize of the occluding object, as the claim says in terms, not of the billboard. If we are right on this construction ground alone, the SVB system would not infringe, but the claim would be valid over the Nevity prior art on the judge's findings as to obviousness. I've got an attack on that, but within ground 1, the result would be not infringed, but valid. The specific question of construction is whether integer 12.5, detecting an occluding object based on an image property of the occluding object and the detection image, can be construed so the image property of the occluding object can be the simple pixel brightness of an individual pixel in the detection image, where the defining characteristic is the signature of the billboard, not the occluding object. The fundamental problem with the judge's construction is that in the system described by the patentee and meeting the other requirements of the claim, the pixels associated with an occluding object can take any brightness value at all. Because they're dependent upon just the reflection of ambient light, whether we're in the visible spectrum or the infrared spectrum, there is no image property which can distinguish an object based on mere pixel brightness. Thinking about the ice hockey game, some of the players have white shirts which produce very, very bright pixels in all visible wavelengths, and some of the players have black shorts or trousers which produce very dim pixels in all visible wavelengths. However the camera is filtered, there is no property of an occluding object defined purely by pixel brightness that's capable of characterizing an occluding object. You cannot say that an occluding object will produce pixels which are above, or for that matter below, a given threshold. Some objects may, some parts of objects may, but some objects won't, and some parts of some objects won't. The only way that such a system could be made to work is if the billboard were arranged to have a brightness which no real object could realistically produce by absorbing or reflecting ambient light. And that's precisely how the billboard signature systems work. And they only work by emitting a very high brightness, which is never expected to be achieved by a real-world object reflecting ambient light. My learned friend...
Sorry, forgive me. The black trousers
yes.
that you've shown us, the point you're making, as I understand it, is that the black trousers are not emitting anything.
Yes.
Therefore, feature 12.3.1 of the claim, which is the one that says detect radiation outside all of the predetermined frequency ranges and so on, won't detect any radiation coming from the trousers. So there won't be any.
There won't be any.
So a process which used detecting the level of the brightness of a pixel relative to something else isn't going to tell you that the pixel from the trousers is brighter than anything else, because it never will be.
Well, quite. And
hang on.
Sorry.
So I understand, I think, why an approach that says measure the brightness of a pixel and compare it to something isn't going to tell you that a trouser is an occluding object in that example. But that doesn't mean that this method doesn't work for the I don't know, a red shirt if it's a green background. It would work in that case. So I don't understand why the fact that this method doesn't work for trousers means that it isn't within the claim in the cases when it does work. It may not be in the claim for other reasons, I get that. I do understand that you say it's not there for other reasons, but I don't understand why the fact it doesn't work for trousers means it isn't in the claim.
My lord, it's a slightly subtler point in that when one looks to fairly construe the claim, one looks at what the patentee is teaching and how it works through. The question that the judge was approaching was, would the skilled person understand pixel by pixel to be the simplest possible detector that could be being used for object detection? And we say not when it doesn't work. It's one thing to say the language of the word is absolutely clear. It says pixel by pixel, and it's no objection to come along and say, well, there's a raft of cases where this wouldn't work. In fact, most real-world events that have some sort of dark clothing wouldn't work. But it's a different thing entirely when one's coming to arrive at a claim construction which fairly balances certainty for third parties with fairness to the patentee. And if one's going to have to come up with a construction where the patentee is saying, based on teaches algorithms that would work and object detection, which has got a meaning to those in the art, be looking in a much broader sense than merely pixel brightness. Is it right to construe the claim in such a way that in the real world it would never work, notwithstanding you could find examples in the laboratory where you ensured that players, not only including their clothes, but their face, their eyes, their pupils, dressed up in like those green screen suits that people run around on film sets. I mean, if you can make it work in that situation, that's one thing. But is it a fair construction of the claim? And we say that the judge pushed that to the limit. And it goes even further when you get to our ground two. Standing back and looking at what the patentee is teaching, he's talking about a system where object detection, using the algorithms that were common general knowledge, would work. Do you press it to an extreme where in the real world it wouldn't work? And my learned friends are led to say, they're aware of the problem, and they're led to say, as I showed you in their skeleton, that objects in the foreground will appear bright. That isn't the case. They know that's not the case, but they're pressing it because once you start admitting that in practice, real-world objects won't appear bright, they won't have this characteristic, you start seeing that the judge's construction goes too far.
So
rips the heart out of the object.
Is your point, see if I can put it in my own words, see if I've understood it, that the patented system, as construed by the judge, will not detect a pair of black trousers, and therefore, if the system is operated in accordance with that construction, the space where the black trousers are will be overlaid with the adverts, which just as if it was part of the billboard, and because that's a system which obviously doesn't work, that can't be the right construction for the patent. Is that broadly what you're saying?
My lord has precisely my point, and it's not a proper way to go about construing a claim to come up with a laboratory-only version where we say for this ice hockey game, well, we certainly won't play in an ice hockey stadium where people can choose what they want. everyone needs white clothes with white numbers on, white sticks and white goalposts running around so that they can be detected. Because if the level of light coming from them drops too low, they'll all get overwritten. And it's one thing if the claim expressly claimed pixel by pixel, if the patentee taught pixel by pixel, to say, well, you then run into the fact that the claim clearly is intended to cover this. Now the question moves into one of sufficiency. But where the claim language doesn't mandate pixel by pixel, and the judge has to reach a conclusion which fairly reflects the patentee's teaching, then taking it to such a limit where the system taught by the patentee doesn't work is going too far.
Because what's the point of 12.3.1?
12
on your construction of what object detection involves, which is this higher processing, which can detect black trousers, as I understand it, that's the point you're making. What's the point of the integer in 12.3.1, which won't detect the radiation coming from the black trousers?
So what we've filtered out in the normal operation of the system is the moving billboard. So you end up with the Where's Wally example. When 12.5 is working on is the image as a whole, and within the object detection algorithms, there are bits of that object that aren't seen, don't appear as such. But the whole point of using the object detection algorithms is they can fill out these holes. The experts gave quite a bit of evidence to it, that when you know, for example, looking at my face, that I've got dark pupils in and around my head, the object detection algorithm can say, well, that dark pupil is clearly part of that object. So it's not about the radiation that comes from me. It's over to the image processing algorithm and how well can the image processing algorithm see in grayscale, where some things are bright, some things are dark, some things are in between. But I've got a lot more information. I've got a silhouette. I've got a border to me. I've got the expectation of size and shape and position. The algorithms are capable of working out that the black dots within my face aren't sudden fused through to the billboard. They are actually part of the object, which is a person. So, as my learned junior says, the point of 12.3.1 is setting up Where's Wally. It's clearing out the background so that what you remove all the noise from the background, let the object be in its best possible position. You're not making it better than it was in a full colour image, but you're not making it worse either. You're isolating so that now the referee with black trousers standing against the background hasn't got Kia Motors and Enterprise Car Rental and Sorrento and that around him. He's on a nice, clear, white or dark background. And the object detection algorithm has got the best chance it can have. That's what the patentee's teaching is. And both experts said that the image processing techniques that were available at the time and were part of the common general knowledge could do that sort of activity. And no problem with it. From behind says the same thing. 12.3.1 makes the object stand out from the visible display.
Just to be clear, it doesn't make the trousers stand out, does it? That's the point you're making.
Yeah. It makes the background uniform.
Does it make the trousers stand out? No.
Well,
that's what you spent the last 2 hours telling us.
Yeah. So, my lord, if one looks actually specifically at tab 20.
8.
And just to give you a specific example, just to the rear, what's my lord saying? Just to the rear of the referee, looks like the end of the letter S or the letter E is part of the billboard, and it's merging with the player. And what the system does and remembering that the system requires uniform and monotone. It doesn't require uniform monotone black or uniform monotone white. What it does is it removes that noise from the background so that you've still got the black trousers there, but they're not wrapped up with what's on the display board behind them. As we say, the problem is when you start looking at a single black pixel, you've got nothing more to look at. The only way you can make your decision is on a threshold. Is it bright? Is it dark? Is it brighter than this level? Nothing more there. With a non-uniform shape, because you're looking at the higher order processing, you're looking across a range of pixels, you have the best available information to be able to see, just as my lord and I can see, looking at this, even though this is completely black, we can all see that these are the legs of the referee. And so can the image processing algorithms. They're not put, the higher order processing algorithms aren't put off by is it black or is it white. Because if you do is it black or is it white, you can't do it. But if you stand back and look at the image as a whole and you do image processing to find object detection in exactly the same way that we as humans can do object detection at a very complex nature, looking at a picture, that's what the computing algorithms could do. That's what the computer algorithms that the patentee talks about using do and why they work, whereas this doesn't work on a pixel by pixel basis. Now, on a pixel by pixel basis, this is precisely how the billboard signature systems work, but they can only be made to work by emitting that very high level of brightness. Because then and only then can you say, nothing in the real world, nothing in the natural world should give me that level of brightness. If I'm seeing that level of brightness, I know it's billboard. And my learned friends can't say that such a system would be in the scope of the claims, because they accept it would then be invalid in the light of nevity. It's also a system looking for billboard properties, not object properties. Now it's important to note that you cannot make a signature system work by making the billboard signature black. Because as we've been discussing, black, the reason for it is that black overlaps with the range of brightnesses which can be expected in the real world objects. You can't go looking for pixels that are not black to find occluding objects when the objects themselves can be black. Putting the squeeze and the way that the pixel by pixel signature systems aside, my learned friends have other construction problems. It is a fundamental requirement of their construction that the display device in the claim is a special display device which is absolutely black in the detection image. But there's no such requirement in the claim at all. The general teaching of paragraph 27 is the patentee's object detection system doesn't actually even require a billboard. And even when the patentee discusses physical billboards with moving images, he doesn't set any limitation upon the type of billboard that he has in mind. Indeed, the fact that the patentee is contemplating the widest possible range of billboards, such as the red LEDs on white that we discussed earlier, is readily apparent from paragraph 26 of the patent, where the patentee says, having discussed an LED display, herein LED may be replaced with any light emitting pixel or light reflecting pixel of a display. And it's expressed in the claim at integer 1.12.1.1.2 in order to display moving images, the display is permitted to emit radiation in one or more predetermined frequency ranges, which, as we discussed earlier, specifically covers, for example, pure red LEDs on a white background. When my learned friends seek to say in paragraph 9 of their skeleton that the patent's invention arises by exploiting a particular feature of ordinary RGB LED billboards, that's fanciful. The claim isn't limited to ordinary billboards, RGB billboards or LED billboards. The patentee's alleged fundamental insight is simply wrong in each and every respect. And just picking up the black trousers, once one realises that the billboard doesn't need to be black, it can be white, the problem with the referee's trousers in this particular example goes away. As we can readily see from the claim, and there's no attempt to define what the reflective or emission properties of the billboard might be outside of the frequency bands used to emit radiation to form the moving image. Nor are there any other requirements of the billboard specified at all. One of the areas, and we'll come to this more in ground two, that the judge made an error on, is he misunderstood 12.3.1 to require the camera to exclude all light coming from the billboard so that it's always dark. That isn't what the claim says. The claim says remove those that are used for the moving image, because that's what the patentee wants to do, remove those videos from playing. It doesn't say anything about what you're left with. Now, we mentioned in passing that even if the claim were somehow limited to ordinary RGB billboards, Professor Steed's unchallenged evidence, which we looked at this morning, was that ordinary RGB billboards suitable for use in sporting events and the like included mesh billboards where there were gaps between the rows of pixels and ones that weren't absorbent. So any idea that the billboard as a whole would have had some sort of dark absorption signature fails entirely on the facts. What my learned friends are left doing is asking my lawyers to look at computer monitors and the like, where for particular reasons attempts are made to make the screen appear visibly dark when not illuminated, so that you get a really good range of blacks through to whites when you're watching movies and things of that nature. But if you're not watching movies, you're just trying to say Coca-Cola or Eon Next or whatever the message might be, Heineken advertisements, perfect blacks aren't what the systems are looking for. And the evidence is that's not how these billboards are constructed. And as I touched on earlier, the court is reminded that the protocol to Article 69 of the European Patent Convention requires the court, when construing a claim, to seek to draw a balance between fair protection for the patent proprietor and a reasonable degree of certainty for third parties. We respectfully submit that construing the claim in the way that AIM suggests, to ignore the whole teaching of the patent about improving the condition to be able to do object detection and then detecting objects based on image properties of the occluding objects, and then suddenly to cover a system which in Dr. Thomas's, their expert's own words, is conceptually and technically different to the teaching of the patent, and which, except for in a laboratory environment, does not work, and which requires features to be implied into the claims about a billboard which is taught not need to exist at all for the purpose of object detection, is just wrong in principle. Now, the judge's analysis approached the question of construction starting at 120. Wasn't just looking at the plot. This is obviously an important bit, looking at the judge's construction. I'm in your lordship's hands. I'm very happy to do it now, but I don't think I can promise to do it in 6 minutes.
Well, why don't you go on for about 5-6 minutes and then find a pause?
I'm grateful, my lord. So, core 8, paragraph. Yes, core 8, paragraph 120 on page 117 of the bundle. We get the judge's start of claim scope of construction, and it's notable that rather than to seek to construe the claim as a whole, the judge focused on issue 1, on the construction of feature 12.5. Now, as always, a claim is to be construed as a whole, and although areas of dispute between the parties are necessarily the court's focus, it is important that the overall claim and the impact of the construction of an individual integer is kept firmly in view. And there's nothing in the judgment where the judge took the common step of standing back and making sure that the resolution of the construction dispute made sense to the claim as a whole and that it fairly reflected the patentee's contribution. And as far as we can discern, the error the judge appeared to make was to think that pixel-by-pixel detection systems based entirely on pixel brightness are of general application, and that the detection step at integer 12.5 ought to be broad enough to cover such a very simple process. That's what the judge says at 140 as he's bringing the argument to its head. Now, in this regard, it has to remember that there's no discussion of pixel-by-pixel brightness processing in the patent at all. The only reason it was being considered by the judge was because it's the approach taken in the billboard signature systems of the specific prior art and the alleged infringement. The skeletons, the expert evidence, and the submissions were replete with pixel-by-pixel processing systems and how they work. So it's perhaps not difficult to see how the judge formed the impression that pixel-by-pixel processing was just an example of the very simple approach to processing in these image replacement systems. But as I've sought to explain to your lordships, that's not the case. The first problem with the judge's approach is that pixel-by-pixel detection systems based on pixel brightness only work in billboard signature systems, and the claim as a whole is not, we say, a signature system. Dr. Thomas agreed the system taught is conceptually and technically different. I keep coming back to that. The second problem is that the pixel-by-pixel approach only works to find visible billboard. It doesn't work to find occluding objects. In other words, billboard signature systems, not occluding object signature systems. And integer 12.5 is specifically about detecting occluding objects based on the image property of the occluding object, not on the image property of the billboard, not looking for the signature of the billboard. It's about the property of the occluding object. And turning specifically to integer 12.5, there's nothing in the judge's construction which properly addresses based on image property of the occluding object. It has to be image property of the occluding object and not just the image property still simpliciter. As we've explained, pixel brightness can't be an image property of an occluding object, especially in a light on dark limitation, which AIM is contending and succeeded in selling to the judge and is the subject of my ground too.
Mr. Nicholson, sorry, you always read this as based on an image property of the occluding object, and then you stop. and I confess I don't quite understand what the claim is trying to say, but it is notable that the claim says based on an image property of the including object and the detection image.
Yes.
What is that and doing? Can you help me with that?
So the point is you take the detection image and you are using the detection image and the image property of the occluding object. So here's my picture is the detection image, and then I go through it with my image property of the occluding object to find the objects. So there
You're finding the image property in the detection image?
No. The way in which the body of the specification uses based on image properties and based on spatial frequency characteristics and the like is these are the things that you put into the image detection algorithms. You can't set up an image detection algorithm and give it no information. So what you give it is the image properties of the thing you're looking for, and that's enough to define for the algorithm. It can then turn its handle on as many detection images as you feed it, and based upon the properties, and I typified this earlier, of a contiguous round block of pixels representing a football, and I accept that's massively simplified, but something of that nature. The algorithm can then process. In one hand, it's got the image properties of what it's looking for. On the other hand, it's got the detection image. It processes the detection image with the properties to find the objects. So detecting occluding objects based on the image property of the occluding object and the detection image. Now, as we say, pixel brightness can't ever be an image property of the occluding object, especially in the light on dark limitation which we're contending. And just to be clear about that, the reason it can't is that for an occluding object, the brightness you see depends upon how much it's illuminated by ambient light. And that's the same whether you're in a light on dark or a dark on light system. You've got no idea what brightness you're going to get from a pixel. It's how much light's on it, what colour it is, how absorbent it is. Whereas for a billboard, when you fill it with light of a particular colour and shine that light out, you do know. And that's why there's a material difference, a technical and conceptual difference, accepted by both experts, between image properties of the two systems, which we say is reflected in the express wording of the claim, image properties of the occluding object. And the judge's failure to focus on the entire expression in the claim is evident throughout his construction section of this part of the judgment. We see, for example, at paragraph 134, the judge says in terms that Supponor's case was that image property is limited to higher order processing, and the image property is a broad term. And the skilled person's first impression of the patent would be that it was very general. Now, undoubtedly, a first impression, image property is a broad term, but that's not the language of the claim. Image property of an occluding object. Purposively, that property is to be used to allow the detector to detect occluding objects which appear in the detection image, with no predictable level of their pixel by pixel brightness. And once you realise that it has to be the property of the occluding object, and once you realise that unless you set up a laboratory environment, the pixel brightness of an object occluding the board is utterly unpredictable, you realise it cannot be a defining feature upon which the detector operates. Had the judge focused on image property of an occluding object and appreciated that in order for the patentee's system to work, whatever the image property might be, it needs to enable the detector to work. That is, be able to detect occluding objects which appear in the image. He would have appreciated that pixel by pixel brightness is not a usable property in the system, which is the subject matter of the claim as a whole. And as we say, pixel brightness is only usable as an image property in a billboard signature system, and even then as an image property of the billboard.
Right.
We say
is this a convenient moment?
yeah, one
Yes?
paragraph moment.
All right.
We say the claim requires proper object detection, an algorithm such as that taught by the patentee, that looks at collections of pixels, looks at at least regions of the image, to recognise properties that make up a person or a football or the like. If that is right, we say it is, then the claim is valid, subject to our appeal on obviousness over nevity, but it isn't infringed by the SVB system because we don't have any form of object detection with pixel by pixel billboard. My lords, that brings me to the end of ground one and would be convenient.
Right, and you're still on course to finish by about 3:30, I take it?
Yes, we are.
Very good. Tupper.
All right.
Let's go for it.